ePrivacy itself, I think, is celebrating a 21st anniversary now from the very original 1997 directive, and the Commission, of course, is celebrating this with pushing the reform. There was an ambitious goal set, as was noted, for May 2018, which has not been met. And I think there was also perhaps some pressure that was put on the Council to reach general approach in June, but it became quite clear to us this year that this deadline just wasn't going to be met, that we needed a lot more work on serious areas of uncertainty. We have indeed made considerable progress, particularly under the recent Bulgarian presidency. But there are at least 4 key areas of uncertainty that we've been discussing in Council, and that we feel that we cannot simply leave up to the regulators to solve these problems after we legislate. We need to solve and address them now. So I'll give you a very brief overview of what those 4 areas are, the gory details, as was said. One of the significant areas that we've been discussing at length in Council in the working groups is the relation with the GDPR. To what extent are there overlaps, and when does one instrument prevail over the other? Does GDPR prevail over e-privacy, or vice versa? And as I believe you mentioned, there's the lex specialis principle, which means that e-privacy is meant to prevail when there are specific rules. That perhaps isn't quite as clear as it could be. In Council, we've been discussing different examples. So you may have something like e-privacy Article 6, which does provide more specific rules than GDPR Article 6, legal basis. And so in that case, e-privacy prevails. However, e-privacy does not have provisions on the rights of data subject, like in Chapter 3 of the GDPR, nor is there a section on international transfers. So in those areas, if it's personal data, then the GDPR prevails. So you can have actually both instruments applying to the same set of data there. There's questions in Council about just when still does e-privacy prevail. We're looking perhaps at what Article 9 of the GDPR, what that means. Is e-privacy Article 6 legal base? Does this offer more specific rules to that? Is it equivalent? Or does GDPR Article 9 prevail? And indeed, we've been looking at whether this varies depending on the type of data. The e-privacy text now states that if there's content data, so the content of communications, then this only comes under e-privacy scope during the transmission, and at times when it's at rest, it is going to come under the GDPR if it's personal data. So we've had quite lengthy discussions poring over all these aspects, including 2.5 hours, really memorable meeting, discussing what the precise meaning of transmission was and when that ends. If you wanted gory details, that was quite it was a grueling meeting to go through. But we did it because we felt that these issues absolutely need clarifying. It's really important we know which instrument applies, and it's even more important that this is actually made clear in the text for those who will be using it after us, so the stakeholders, the businesses, especially SMEs without lawyers, and individuals as well. A second key area that we've been poring over in Council is the question of which services come under scope of e-privacy. This is the question of ancillary communication services, so ones which do not have communication as their primary core function, but they do enable communication. So the classic example we use is a gaming app. Its core purpose is not communication, it's to allow multiplayer games online, but it does enable players to, say, invite each other to participate in a game and then to participate in a chat during that game. So we've been looking at the type of factors that might make a service an ancillary service that comes under e-privacy, and the factors that do not, such as is there a finite number of people who can participate in this communication? So if you take my example of the gaming app, if you had one that was only invitation only, so finite number of players, that would be caught under the current text. If you have something that's completely open to infinite number of people, that would not be following the definition that's been established in the Electronic Communications Code. Another factor is whether whether the provider is indeed a party to the communication themselves. So we've been looking at examples where a user accesses a customer service applet on the website. Does the bank come under e-privacy now as an ancillary service? And the latest thinking is no, they do not, because they are a party to communication. However, the gaming app that I mentioned before would, because they're not party to the communication between players. We've had, so you can imagine, Council has taken quite some time working on e-privacy, and this is due to very long, very complex discussions about matters such as this, what counts as an ancillary service. We've been looking at what other services could be potentially captured, accidentally or deliberately. Would it capture blogs, where people allow certain users to comment on? If I set up a Google Docs for my team and I create a document and they have an argument in the comments about a certain aspect of the document, is that a communication service? Have Google created that communication service, or have I, by actually being the one to create that document? So the UK, we published a technical note on this for the Telecoms Working Party, and we've been driving discussions to get clarity on these points. We think it's very important to resolve. It's really important for assessing the proper impact of e-privacy regulation to know what services are in scope, as well as the clarity point. And in particular, this was something that wasn't considered or costed in the impact assessment. And so that means we have to pay even more attention to it right now in Council. The third area that we've been paying a lot of attention to is the question of legal bases, which were briefly mentioned. We've been keen to ensure that all sorts of vital communication features are still permitted under e-privacy. There was an issue that the emphasis on dual consent, so getting the consent of both the sender and receiver for communications, might mean that certain features could no longer operate. At the very beginning, it did seem that actually you wouldn't be able to send an email under Article 6. That was due to a drafting error, fortunately. But the text did also mean that things like spam filters wouldn't be able to operate because you're not going to get the consent of the person who's spamming, and other features such as other accessibility features, so text-to-speech, translation services. All these that depend on scanning the content of communication during its transmission rather than after. So there's been a lot of progress on this actually in Council. There's been work on extending the legal bases and some very helpful language put into the recitals by the previous two presidencies. But because these areas are so much at stake with these aspects, these features that we need to enable, we are still doing our due diligence to ensure that nothing is left out here, that there is full coverage. And the final area, our favourite one, as I mentioned, Cookie Monster. We've been looking quite close in Council as to whether it is indeed possible for the browser setting provisions in the regulation to operate effectively. These require browsers or other software providers to block cookies or similar techniques like device fingerprinting at the user's request. And we've been querying to what extent this is technologically possible. Of course, we understand that this is a matter that actually does need to be addressed. There's been a lot of problem, a lot of concern that there isn't valid consent for cookies. And in that respect, it's going to be interesting to do a proper evaluation of the changes that the GDPR has brought in this respect. As was mentioned, we've been seeing a lot more proper consent notices for cookies. In Council, and this is the UK point, we posed 6 key questions that we felt needed to be answered for any solution to this problem, whether it's the Commission's solution or another. And these 6 questions were co-opted by the Presidency and then put to the Commission. And they revolved around some of our concerns, such as that this idea was putting, sort of going against the principle of the polluter pays and putting a cost on browsers rather than the websites in this case, and that it was exposing them to the sort of legal risk, to the risk of liability for fulfilling an obligation that might not always be fulfillable. There are techniques such as device fingerprinting that I mentioned, that it's not clear that it's always possible for the browser acting alone to block this. And something like this might not be a problem when you have the existing market solution. So you have browsers who are voluntarily offering cookie blocking, and not being able to block all cookies or device fingerprinting isn't so much an issue for that. But it does become an issue when you're imposing a legal obligation on them with the prospect of heavy fines and no limitation at all on this in the text so far. So that issue and the other four, it's just a small taster of these very quite complex discussions we've been having in Council. I know some of you may be wondering why it's taken so long. Well, you can see we have been kept very, very busy with these discussions for the last 18 months. And I believe the incoming Austrian presidency is more than up to the challenge of addressing these issues. But it does seem clear to us that we cannot rush legislation on this. We cannot rush straight into political trialogues with the Parliament without further reflection on the key issues that I've just outlined and various other points.